boss in the office, Lady Beatrice Jedi Agba, Solicitor General of the Federation and Permanent Secretary, ON MNI, Chairman, Body of Benchers, I think it's represented by Ashiwaju Adegboyega Omono, my President and the President of Presidents of Nigerian Bar Association, Chief Afam Sigwe, Senior Advocate of Nigeria, the Chairman, Law Reform Commission, Professor Dakas, C.J. Dakas, an erudite scholar, members from the stakeholders here present, and I use that world-renowned Professor Idonije SAN as a point of contact. Very distinguished ladies and gentlemen, I want to say that I am greatly appreciative to the Senate Committee on Judiciary, Human Rights, and Legal Matters for the opportunity to provide my views regarding the proposed amendment to the Terrorism Prevention and Prohibition Act. While the Ministry shares the National Assembly's resolve to eliminate the existential threat of terrorism, I wish to inform that the critical review of the proposed terrorism bill has raised certain concerns, particularly relating to the inclusion of death penalty as a prescribed sentence for convicted terrorists. Our position is informed by a rigorous assessment of the legal, strategic, and human rights considerations and discussion across or offshore in diaspora, which are outlined below for the committee's kind consideration. It is undoubted that the bill proposes to address the legislature's deep concern over the escalating security challenges facing our dear nation. However, I believe we must be cautious not to adopt a policy that, while emotionally satisfying, may prove counterproductive to our ultimate goal of a safer Nigeria. From a critical perspective, a tactical perspective, it is our view that the proposal to include the death penalty for convicted terrorists should be viewed because it inadvertently facilitates the martyrdom trap. It is critical to note that the fight against terrorism deals with an enemy often driven by radical ideologies, where a state-sanctioned execution is viewed not as a deterrent, but as a validation of their cause. We must avoid giving these groups the matters they need to fuel their recruitment drives and incite further retaliatory violence against the state and its citizens. Furthermore, we must consider the protocol bottleneck that the inclusion of death penalty creates for international cooperation and mutual legal assistance. As the committee may be aware, many of our international partners in the global war on terror will not extradite high-profile suspects if they face the risk of capital punishment. By including this provision, we may inadvertently create a safe haven abroad for the very masterminds we seek to bring to justice, as foreign courts will block their repatriation to Nigeria on human rights grounds. Beyond these ideological concerns, it is critical to confront the harsh administrative reality that has historically undermined capital punishment in Nigeria. As you are aware, there is a long-standing and pervasive reluctance, except during the military era, among the state governors to sign execution warrants, often due to moral, religious, or political considerations. This hesitation has created a de facto moratorium that leaves condemned terrorists sitting indefinitely in our correctional facilities. The state of legal limbo not only serves as a conscious psychological drain on our justice system, but directly contributes to the chronic overcrowding of our prisons. By keeping these high-risk individuals in the general prison population for decades, we inadvertently create radicalization hubs where convicted terrorists can influence other inmates, posing an ever greater long-term security risk to the Federation. In addition, the risk of judicial error remains a reality in any legal system. The finality of death penalty leaves no room for the rectification of errors should fresh evidence come to light. To maintain the moral authority of the Nigerian state, we must ensure that our punishments are both firm and reversible in the face of new facts. While appreciating the critical work of the committee, it is my considered view that the proposal for death penalty in the Terrorism Prevention and Prohibition Act Amendment Bill SB 969 be dispensed with. Our focus should remain on the certainty of punishment rather than its ultimate severity, and the bill may consider alternative sentencing such as life imprisonment without the possibility of parole for persons convicted of such offences. Mr. Chairman, distinguished ladies and gentlemen, the Federal Ministry of Justice advocates for a robust legal framework that prioritizes the certainty of apprehension and the speed of conviction over the ultimate severity of the sentence. We recommend that the bill should focus on enhancing investigative powers and strengthening witness protection protocols to ensure that terrorists never return to the society. I thank you for giving me the platform, and I wish you very useful deliberation. Long live the Federal Republic of Nigeria. Thank you. Thank you, Honorable Attorney General for the presentation. We're going to call on those who may have presentations regarding terrorism. So, Mr. Kennedy, would you see that rule of Nigeria?
In other words, we disagree with provisions that seek to place a blanket death penalty on everyone, irrespective of how connected they are to the offense. The second point, of course, is the conceptual integrity of terrorism law. Internationally and even locally, terrorism is defined as intention to intimidate a population or compel a government, or combined with ideological, political, religious, or insurgent motivation. So that when you prescribe any form of kidnapping that has nothing to do with these ingredients, as kidnapping or as terrorism, then we have lost the true meaning of terrorism. And that's what this bill seeks to do, removing these defining elements. It is important to note that we have an existing legal framework on kidnapping. It is already criminalized under the Penal Code, the various state criminal codes, and numerous anti-kidnapping laws passed by state legislature. Unfortunately, this bill does not sufficiently address jurisdictional overlaps between federal terrorism prosecutions and state criminal jurisdiction. This bill makes no provision for how prosecutors would exercise discretion and forum selection. And of course, there will be potential conflict in sentencing outcomes. If you bring a terrorist under this new act, he must be sentenced to death. A kidnapper, under the new act, must be sentenced to death. But in some other states, the maximum sentence is life. So the bill needs to consider all of that. Particularly, we've looked at the new section 47A being proposed, particularly subsections 1 to 3. The bill provides, these provisions indicate that kidnapping or hostage-taking constitutes terrorism, whether or not connected to a terrorist group, ideology, or network, and regardless of the number of persons involved, physical harm caused, or payment or demand for ransom. This provision collapses the distinction between terrorism and serious conventional crime. It disregards the mens rea traditionally associated with terrorism, namely the intent to terrorize the public or coerce governmental authority. And the absence of qualifying thresholds risk over-criminalization, allowing routine criminal conduct to be prosecuted under the most extreme security framework. While kidnapping is a heinous crime, its blanket classification as terrorism is legally overbroad and inconsistent with established criminal law taxonomy and international best practices. Subsection 4, we also find subsection 4 problematic because it prescribes a mandatory sentence without the option of fine or lesser punishment upon conviction. Firstly, the mandatory sentencing regimes undermine judicial discretion and may violate international human rights obligations of Nigeria. We have also noted that the appellate courts in Nigeria have increasingly expressed disapproval of laws that eliminate consideration of mitigating circumstances. The absence of gradation, regardless of harm, role, or outcome, offends the principle of proportionality in punishment. I think the HAGF also spoke to that. So the NBA is strongly opposed to the imposition of a mandatory death sentence, particularly where no loss of life occurred, or the offender played a peripheral role, or the offense was merely attempted or conspired. Because we find in the bill that even for conspiracy, the punishment will be death sentence, mandatorily. Yes, I am. Yes, I am. Thank you very much. Another source of concern is equal penalty for attempts, conspiracies, and incitement with completed offense for sentencing purposes. Subsection 5 also speaks to ancillary liability, punishment to informants, transporters, harborers, and persons providing logistical support. Again, the bill seeks the mandatory sentence, death sentence for these persons. The NBA is of the view that this might impede cooperation by these persons, especially where they may have been acting under duress, and it doesn't consider the fact that mens rea is indeed important before criminalizing or conviction. In summary, the NBA proposes and recommends that the classification of kidnapping as terrorism should be limited to cases where the court has to deal with organized crime or a terrorist network, or the terrorism is undertaken with an intent to intimidate the public or coerce the government. We also propose that the mandatory death penalty be replaced with a discretionary sentencing regime, including life imprisonment or death in aggravated cases. We also believe that a graduated penalty should reflect matters such as the degree of harm, the role of the offender, and the outcome of the offense. We believe that this act, or this bill, reflects a legitimate legislative response to Nigeria's grave security concerns. However, in its present form, the bill raises profound constitutional, doctrinal, and policy concerns. The NBA urges the Senate to adopt a measured, principled, and constitutionally compliant approach that strengthens public security without undermining fundamental legal safeguards or the integrity of the Nigerian criminal justice system. Subject to the incorporation of the recommendations outlined above, the NBA remains committed to supporting legislative reforms that enhance security, uphold the rule of law, and protect fundamental rights. The NBA is grateful to the committee for hearing us out, and we have provided 30 copies of our memorandum to the Secretary of the committee. More details are in it. Thank you very much.
Dimension, and any definition of terrorism that goes beyond this framework is not consistent with international global dimensions regarding this definition. Second, the Commission shares the views expressed by the Honorable Attorney General of the Federation regarding the issues surrounding punishment, and in particular, the issue of death penalty, especially given the fact that the global trend is a shift away from death penalty. The fact that at the federal level and in many states, there is already in place a moratorium in relation to the execution of the death penalty, which reinforces the general disposition in this country regarding the subject. Third, the Commission expresses the view that where, as you find in the proposed legislation, that even an attempt is categorized in the context of punishment as a completed act, and in respect of which the death penalty is proposed, clearly would not also pass the test of proportionality in criminal legislation. We also take the view that given the fundamental intersection between some of the human rights concerns and the security imperatives that are warranted by this bill, the Commission takes the view that there might be need for a sunset clause, pursuant to which those aspects that raise these fundamental intersection issues between human rights and security are then examined within a period of about 3 to 5 years, at the end of which these provisions would automatically lapse unless the National Assembly activates them. So essentially you have this sunset clause that serves as a guardrail. And because we have submitted our presentation, we have also identified a number of issues that deal with drafting, which are technical issues, and I won't go into those ones. We appreciate the opportunity to make this presentation, and we are confident that under your leadership, the Senate will produce a bill that not only responds to the realities of the grave security challenges that we face, but will also be mindful of Nigeria's domestic and international human rights obligations. And I note, Mr. Chairman, finally on this point, that both in your remarks and in the remarks of the representative of the Senate President, you underscored the imperative need to treat human rights and security not as trade-offs, but to treat them in a manner that is mutually reinforcing and responds to the challenges that we grapple with. I thank you for your kind attention.
I will be very brief. This is to get to the General and the NBA and the human rights. I think they are saying the same thing. Basically, you are opposed to death penalty. And you cite two reasons. One, international conventions. I'm not sure whether those are ratified by Nigeria or not. And some moratorium, some external positions on this issue. When each time you use the word international community. The second is about, you more talked about no evidence that death penalties have stopped people from committing murder. By the same logic, the absence of death penalty, there is no evidence that it has also discouraged would-be murderers. So this question is either here or there. Now, we in the Senate, in drafting this bill, takes into account the sentiment of the Nigerian people. For example, you are at liberty as lawyers to, in the open, defend a murderer, and you go home and sleep. I, as a senator, when somebody from my constituency is killed by a kidnapper or set of kidnappers, and they see the person walking freely, or he goes to court, and the court asks him to go and spend 5 years, 10 years in prison, meanwhile their loved ones have been killed. Our people do not understand that as justice. The law of society must reflect the values of the aggregate views of community, not of the learned minds, not of the senators. Today, I still stand. I have been harassed, not only me, every senator here, each time. People from our communities across the country are kidnapped, and in the process, some are killed. Women have been raped, and after rape, they are killed. Children have been orphaned. So, for those who talk of human rights, whose right? Do the right of a widow, of a woman who has been widowed by the father, the husband has been killed, is it human right? The right of a widower whose wife was killed by kidnappers, does she have human right? Children who have been orphaned, who as a consequence may not be able to go to school because their parents have been killed in the course of being kidnapped or even after being kidnapped. The right of the children, they do not come within human rights. Is it the right of the criminal that matters, not the right of victims? For me, all of this fell in the realm of value system. You can hold the view, as a matter of value system, not law, that people who kill need not be paid. It shouldn't be an eye for an eye. That is a value judgment. And law is a function of sets of values of those who make laws. So my view, which is informed by the views of my constituents, and we have some senior lawyers, let's say, from a donut. You know how I have been blackmailed, harassed, intimidated, when kidnappers kill people from minor seminaries in Nigerianpolitics, when they kill the Reverend Father Tinubu, when they murder farmers in various local governments in Edo North, and people are calling for their head. When they apprehended, you remember what led to the burning of a police station, because the policemen were trying to protect a man who has killed 7 persons and buried them in the compound of someone in Nigerianpolitics. The views of this community is that he who killed should face the wages, which is killing. And I speak as a man, because somebody talking about congestion in prison because governors are refusing or hesitating to sign. I want to say to my credit, I use the word credit. Credit need not be like medicine. In the real world, if something is positive, it's celebrated. But in medicine, if you test positive to HIV, or you test positive to any disease, it is a problem. So, for me, it is even not correct, or let me say it is arguable, the definition of international community. As we speak at the general staff, with due respect, America still executes people in some states. They are part of the international community. China is one of the world's most populous nations. As we speak, they carry out execution even of cases of corruption. As we speak, India, which is the world's largest democracy, they execute if you commit an offense that carries death penalty. So, who is the international community? Is it the minority in Europe? Because we should be looking at the totality of world population and ask ourselves, if you take together nations with death penalty, these are these nations without death penalty, which one represents more people? So I think we must be careful not to adopt minority Western views as tantamount to international community. I do not accept that. Lastly, sir, and like I said, even the US, the godfather of human rights, they execute electronic execution, and they divide various ways and means of settling, and they still execute it today. They are probably going to elongate the list. So I want to agree with the community people that We as senators making laws, we are looking at what our people want. Our laws should reflect the expectations, the feelings of those who employ us to make laws for them. Those laws must reflect their values. I saw here a very problematic submission by the MBA. Mr. Chairman, in the summary, 2, replace mandatory death penalty with discretionary sentencing, including life imprisonment or death in aggravated cases. Parliament has to make every effort not to transfer powers of punishment to courts and leave the court to interpret laws made by Parliament which reflect the values of society. The role of the court is to interpret those laws, not their personal feelings. That is why when the judge talks about being a Christian, if you were a pagan, will you interpret the law differently? So we have to remove this thing outside the realm of our personal conviction to try and reflect what the ordinary man of the street feels until we move to that level. Sir, and this is the last point. When 2 people approached me when I signed the death penalty, one was a representative of the Pope, and the other was I think EU ambassador. I said, even in the laws of God, and I believe there are lawyers here who are also pastors, the Bible sanctions death. And even God, all forgiving, created hell. And that hell will be populated by those who committed heinous crimes. And in the Bible, no crime is worse than taking the life of the most precious creation by God Almighty. So even my religious values support death penalty. The same thing with Islam. We have Muslim senior advocate here and lawyers. The Holy Quran support death penalty. So in this room, you are either a Muslim or a Christian. In my traditional values, pagans tell us that it is forbidden to kill. And if you kill, unless you kill for pagan, whatever. But even in those days, if you kill, the entire community even before you are sentenced, they take law into their hand. So, sir, I thank you for your exemplary gratitude to do what I shouldn't do at this stage, because our business is to listen to them. But I wanted to share with you what informed this. So the sophistry between whether you kill as a terrorist or you kill as a kidnapper is academic. The end result is what matters. The only point you might consider, sir, is if in the act, in the course of kidnapping, you didn't kill your victim, there might be a case. If you did not, but if death results from the act of killing, of kidnapping, the distinction between terrorism, because even terrorists, when they are operating, it is not all of them that they kill. So he who kills should have no right to live. Those views I hold dear to my heart as a Christian, as a believer in God, that God's precious creation should not be wasted by evil-minded men. And if they do, Parliament should have the courage to make laws that will sentence them to the Hades. In the words of Justice Achille, when he delivered the judgment on a woman, on a man who killed a woman, dismembered the body, and buried the parts in different places. He said people like this are only fit for the Hades. I subscribe to those values.
I want to tell you, this is a terrain, with all respect, that I am so well placed to know what obtains. If you, from the nature of terrorism activities, you cannot get them here all the time. They run to neighboring countries. I, as the chair or head of CAU, Central Authority Unit, where mutual legal assistance are usually sought, when you ask for the repatriation of certain, I won't say criminal suspects, the standard they use is theirs. If you do not conform to that standard, they will not. So they prefer to keep them there. In the case of America that you have mentioned, it is not a state matter. It is a federal matter. If you ask for mutual legal assistance, it's not a state of Illinois or Maryland that will do it. It's from Washington. So the standard is by Washington, not any of the 50 states in America. And the position is clear. We have to be very wary of winning something and losing the battle. We have to be very, very practical. We need to fight it. That is one. Number two, you may honestly be swaying sentiment in favor of suspects. The way some of the judicial, I'm not a judge, but the way some of them think at times, and they are human beings, is along the line of, oh, I have a choice between losing this man or convicting him. Oh, if I convict him, I'll be mandated to sentence him into death. They would rather leave him. We have to be very practical. We are all involved. We are all concerned. We are all pained. But softly, softly. Thank you very much.
Mr. Chairman, but I want to remind you that in Guantanamo Bay,